relates to self-ownership of shares. And I raise it in this overall umbrella of looking at the control of structures, because invariably from an asset protection perspective, what we often see people say is, well, we don't want to run the risk, even though they might only be $2 shares in a trustee company, in a shelf company, we don't want to run the risk of those shares being owned by an individual because that individual might be at risk. And if you remember back to cases from a few years ago, such as Richstar, and again, if you want anything on that, it's not in your material, so please shoot me a note directly if you don't remember it. But Richstar was broadly the case where the court argued in a bankruptcy situation that the assets of the trust might be, this case has never been followed, so I don't want to harp on about it, but the assets of the trust might be exposed if it could be argued that the trust was really just the alter ego of the person behind it. Off the back of Richstar, we did see a number of people saying, well, look, we don't want to individually own the shares there. We really want to make sure that the shares in the trustee company are themselves owned by a family trust. So not a completely unreasonable position from an asset protection perspective. Yes, it certainly adds a layer of complication from handing on control, to come back to today's topic, but it was one of those ideas that we saw getting a lot of traction. Unfortunately, what we also saw was people saying, well, do I really want to have to set up another trust? That just creates cost, it creates hassle. Why don't I, and I'll just rely on my red pen one last time, why not I have the existing trust that the trustee company is the trustee of? Why don't I just have that trust own the shares in the trustee company? So I've effectively create a perfect circle. And from an asset protection perspective, you'd say, yeah, big tick, great idea. From a Corporations Act perspective, even with a run-out Nico pen, you actually give yourself a big cross, because what the Corporations Act says, I think, please check me on this, I think it's section 259. What the Corps Act says is that if you have a company, the shares in which are owned by itself, so you've got a self-ownership issue, then that is prohibited and you are at risk of a fine in a monetary sense, and you are also at risk, as I said, I think, of a criminal penalty as well.